So a lot of people think, I would say 80% of my clients think that the other side's lying. And lying, what I always say is lying's in the eye of the beholder. Judges don't get too worked up about who's lying because in their minds, both parties are lying. If it matters and it's obvious, then the judge does care. And the way you prove it is with evidence. So if she says that money was a gift from grandma and, this is an extreme example, but grandma testifies and says, no, I gave it to both of them, then obviously, well, I'm not sure she's lying, but anyway, she's misinformed. If the issue is, say, a domestic violence protection order, and he says that, well, she says he beat her up on a particular day, and he says, no, I was in China that day, and he has airline tickets and hotel reservation that prove he was in China, then obviously you've proved that she's lying. So I guess to some extent, it only matters if it matters. So if it's germane to separate versus community property, if it's germane to the parenting plan and the best interest of the children, then the court will spend some time trying to figure out. If it's simply, she lies here and therefore she's going to lie there, it needs to be really compelling before the court's going to care about it that much. So my advice is, typically, I tell the clients, who cares, don't worry about it. Not always, but that's a common answer. So hearsay is probably the most common evidentiary objection. In our legal system, the judge doesn't consider evidence if it's not admissible. So the threshold matter is always whether the evidence is admissible or not. So hearsay is an out-of-court statement meant to prove the truth of the matter asserted. So basically, your witness testifies that some other witness said that blah, 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 that's hearsay. There are all kinds of exceptions, and there's all kinds of statements that are non-hearsay. So it's kind of an exception, but it kind of isn't. So I remember in law school, the evidence professor summarized that the hearsay rule is not about hearsay and it's not a rule. Having said that, the basic idea is if someone else said it, if your witness is saying that someone else said it, it's not admissible. Exceptions, there's all kinds of exceptions. Excited utterance, the idea is that if the witness said something sort of in the heat of the moment, she didn't have time to think about how to lie, so it's probably true. Another exception is, well, the most common one is a business record. So if the record is kept in the usual course of business, it's not hearsay. Well, it's an exception to the hearsay rule. So a phone bill. AT&T prepared the phone bill in the usual course of business. There's really no chance that the witness, doctored it or made it up. There's a public records exception. There's a whole list, a dozen or so exceptions.